presenter is Murray Godfrey. He is a history professor at Central Oregon Community College, where he has worked since 2012. He received a Master of Arts degree in history from Texas State University, specializing in the history of 17th and 18th century North America. Prior to coming to Central Oregon, Murray previously taught for Austin Community College in Austin, Texas, and Alamo Community College District in San Antonio, Texas. And we're so very grateful to have him with us here tonight. Murray, thanks for being here.
Thank you.
I'm going to go ahead and turn it over to you to take us away.
All righty. I want to thank everybody for coming to today's presentation. So I'll bring up there we go. Alrighty, so I'm going to talk tonight about briefly, just kind of a broad swath of history of how the Supreme Court has influenced American history and its kind of place a little bit in it, and some of my thoughts about where it's going. So I'm going to try to keep this briefer than some of my presentations. If any of y'all have gone to any of my presentations, I'm bad for going overtime. So I'm going to try to keep this one a little more concise. One thing I do want to stress is, or I just want to warn everybody, I am not a lawyer. So I'm a history professor, not a lawyer. So I'm not going to go into the kind of deep legal nuances of the court here, and only kind of touch on some of the surface level aspects of the cases as they related to American history. So Supreme Court, it's one of our three branches. It's the highest court in our judicial branch of government, and it's integral to how our governmental system functions. So it's one of the co-equal branches, along with the legislature and the executive, and that was part of the intention of the framers of the Constitution. But it's had quite a variety of roles, a variety of priorities, and sometimes greater influence and sometimes less throughout the history of the country. So I won't go too much into the background of the court system or why the framers wanted a Supreme Court, but there were several reasons. When British colonists first landed in North America, they brought with them their legal codes, and within very short times, the earliest colonies had fairly sophisticated law codes that were based on English common law. So, but they were somewhat distinct from the way British courts worked. You can kind of see how one of the more substantial courthouses would have looked if you go to Colonial Williamsburg, which is kind of like a little Disneyland of colonial America. That they've recreated there. If you go there, you can kind of see what one of the courthouses would look like. But all the colonies had these once they were established, but they tended to combine the functions of judicial and legislative and executive in different ways. And so there wasn't really that separation, which became important in when the U.S. Constitution was created in 1787. So the way the court systems worked, the executives in colonial America were relatively weak. They were appointed by the crown. In England, the judges, or what were called the justices of the peace, that goes back to the Middle Ages, and so the right to trial and having an establishment of a court system goes back to principles that were set forth in the Magna Carta. So it was important for British people to have courts, but their courts were made kind of to interpret the king's laws. They weren't really for the people. Judges were usually chosen based on their connection to the powers that be, meaning in England, meaning the king. And they interpreted the law usually in favor of the king. There could be juries in England. Actually, a lot of people would not want juries to try them because juries could be a lot more biased than the judges. The thinking was the judges were somewhat more impartial because they were more educated, whereas a jury could be swayed by arguments that might be specious or not. So a lot of litigants would waive their option to have a jury in their trial in the 17th and 18th century British courts. The American courts worked a little bit different than the British ones in that they were smaller scale, and they tended to be pretty wrapped up in, especially in New England, pretty wrapped up in religion. There really was no separation of church and state in a lot of the colonial courts, and the judges oftentimes were pastors as well, and used their religious training to influence their rulings. So there are a lot of laws about all kinds of personal behaviors that people can get in trouble from, and then a lot of concern over things like witchcraft. And you've probably heard about Salem witch trials and all that. One thing the colonists differed from then England, as the colonies developed separately from England in the colonial period, was their emphasis on certain rights that they felt were entitled to them in the court systems. And one of those was the right to a jury trial, or a trial by jury. The colonists very much focused on that. And that somewhat distinguished the colonial legal system a little bit more than the British system. So the practice of jury nullification was something, and this is something lawyers liked, because you could have a jury nullify a judge's decision. So the most famous case that came out of the colonial period was in New York in the 1730s, when a man named John Peter Zenger, who was a publisher of a newspaper, published information that was critical and supposedly offensive to the colonial governor. His name was William Cosby. And the judge was a political ally of the governor. And so the lawyer Zenger's lawyer in the case argued directly to the jury, spoke to the jury, and said, it doesn't matter what the truth is, and whether or not Mr. Zenger actually practiced libel, because we can't discern the truth from this case, or from the evidence been presented, and so you need to acquit him, because he's facing persecution from a political enemy, is how the trial went. And the jury did acquit him. That set a precedent for later American law, and also encouraged jury appeal. So that made it that gave American courts this sense of conscience that they're a little bit more than Britain had, in that there was a sense of conscience and individual rights, and that carried into that carried into America's values in its court system. So when the U.S. was becoming a country, when the Revolution happened, every colony had its own courts, and then they declared themselves states, and so every state had its own courts. And it became clear there was a need for a national court system, and there was not. The Confederation Congress, which was the governing body of the whole United States, after it declared independence, and then until 1789, it was supposed to resolve a lot of the disputes between states, but the Confederation Congress was not really a same kind of government that the constitutional government became. It was more of a political relationship between the 13 states, and kind of like the EU is to today, somewhat analogous to that. And so it was very difficult for the Confederation Congress to deal with like legal disputes between the states. Also, their rights issues were handled at the state level. Most of the states during that period had bills of rights, and that was what protected their civil liberties of the citizens. So, interestingly enough, it's kind of funny thinking about it now. Their discussion about how the court system would work was not that big of a deal at the Constitutional Convention. So the Constitutional Convention, a little bit of primer of your early American history, that it was created because the Confederation Congress wasn't working, and there were potential rebellions in the country. The United States looked like it was going to break up if they didn't create a stronger central government. So a number of states decided to have this delegation, have a convention to revise the Confederation or the Articles of Confederation, and they made the Constitution out of that convention, what became known of as the Constitutional Convention. Anyway, they applied the various the men who went were chosen by their state legislatures, and they applied. Most of them were lawyers, and they applied what they thought was the best legal thinking, which, interestingly enough, didn't involve much discussion of the courts. Article 3 of the Constitution governs the judicial system, and that was not really a big point of contention in the convention of the 3.5 or so months that it went on in the summer of 1787. They didn't really discuss it that much. There was some discussion of how to choose the judges, and they were like, well, we don't want to have them elected because there was a big concern about bias from the voters. So it was decided that the president would choose the court's justices. It didn't even say didn't even specify exactly how the court would work. So most of the rules of the Supreme Court we have were all built by tradition afterwards. Didn't specify how long they were going to serve. It just says they serve as long as they're in good standing or in good conduct, which implies indefinitely. It doesn't say specifically for life, but the justices can serve for life. And in order to change that, you'd have to change the Constitution. So they weren't too worried. Interestingly enough, even though they were mostly lawyers in the room, they weren't too worried about how the courts would work when they were framing the Constitution. They considered that Congress's job to make the laws, and then the courts would then interpret the laws. And the role of the Supreme Court would be relatively limited, which reflects probably why they didn't discuss it that much. Alexander Hamilton actually argued in the Federalist Papers that the Supreme Court was going to be the least significant branch. One big kind of, I don't want to call it a mistake, but a lack of foresight of the people who made the Constitution was that they didn't foresee how dysfunctional Congress would be. They thought the legislature would be kind of the center of American political life. They certainly didn't think the presidency or the court would be more as important as it became. They did want to separate those powers out, but they thought the focus of American political life was going to be the Congress, which it had been for them, and was true for them at their state levels. So in any case, they didn't argue about the courts too much, and left that mostly to the first Congresses to decide exactly how the courts would work. So they didn't even specify how big or small the justices would be. It just says there'll be a chief justice and there'll be some associate justices. At first, there were 5 associates. And one chief, and then they raised that number to 7, raised it to 9, reduced it back to 7, and then they set on the 9 number in the 19th century, which we still have. All that wasn't constitutional; that was created by legislation. So going forward, once the Constitution went into effect, the court didn't have that big of a job for really the first 10 years. So the Constitution established the Supreme Court, but the Judiciary Act of 1789 was what really created the way the legal system started to work. That put the details of like how many justices there were going to be, what oaths they were going to take, and so forth. It wasn't a very desired position to be on the Supreme Court in the first, well, arguably the first 30 years, or even going up until 1891. It was kind of the workaday part of the federal government, and what that was reflected by the practice of writing circuit. So the Judiciary Act established 13 district courts and 3 circuit courts, and but justices weren't compensated very well, and neither were judges, and so the justices were required on their own expense to like ride around to the different circuits, and in some cases judge the cases themselves, or at least provide kind of the constitutional education for the lower court judges. And the thinking also was that this kept the judiciary kind of closer to the people, because you had the judges, different ones would be assigned to go to different circuits to judge various cases, and then if those made it to the Supreme Court, then they met together. But there were more cases for the circuit courts than the Supreme Court during this whole period. The Supreme Court didn't even have cases to really rule on for the first few years, and so it wasn't a very desirable job. And so John Jay, for example, he was one of the framers. He really wanted to be governor of New York, which was a much better job. He became that. His successor, Oliver Ellsworth, also, put the wrong dates on him. He was 1795 to 1801. He also didn't rule on too many, and his biggest contribution to the court was when he resigned, and then they had trouble finding a replacement for him. There was one Chief Justice that in between them that served for like 100 days, didn't actually serve it. John Rutledge, also another framer of the Constitution, present at the Declaration of Independence. He had kind of gone crazy and angry and just refused to serve. And then the legislature didn't want him to serve, and so it was rescinded for him. And then Ellsworth took over, and then John Marshall came after him. So the early court didn't decide a whole lot. They actually complained a lot about writing circuit. So, for example, Justice Iredell, one of the early justices, complained in 1791 that he had the misfortune of spending a night at the inn with a parcel of worthless young fellows sitting up, drinking, gaming, cursing, and swearing all night. So that gives you a sense of what they had to put up with. A lot of the families complained, and so the justices didn't stay in office very long because they were gone half the time, and didn't their families didn't like that. So the big change in the Supreme Court was when John Marshall took over. So John Marshall was at the time when he took over in 1801, a pretty vigorous young man. His father was a planter from Virginia. He became a lieutenant in the Virginia Minutemen and rose to the rank of captain, and served with General Washington at Valley Forge. And after he left, after his service in the Revolution, he studied law and then practiced law in Virginia for about 20 years. So he also was interested in politics. He was a member of the Virginia legislature and part of their ratification delegation there. He was chosen by President John Adams as Secretary of State, And then he was one of the quote unquote midnight appointments that Adams did toward the end of his presidency, literally the last day, and became Chief Justice in 1801. And so that the circumstances of his appointment were part of what caused what caused one of the most famous court cases, Marbury versus Madison, which pretty much defined the power of the court. So before this, the court wasn't terribly powerful and wasn't that important to political life, so unimportant that no one really wanted the jobs. And ambitious politicians didn't want to be, or ambitious lawyers didn't want to be a Supreme Court justice. You'd much rather be a governor or a congressperson. But Marshall changed that. Marshall made the court improved its standing and kind of created the court into what it became in a lot of ways, basically taking power it wasn't exactly given in the Constitution. So the circumstances of the Marbury versus Madison case, basically, John Adams was defeated in the 1800 election by Thomas Jefferson, and he was upset about that, and he thought, I'm going to go out and do everything I can, because he truly believed, and a lot of the Federalists, to the extent there were political parties then, Adams's faction, the Federalists, believed that the Jeffersonian faction, or called kind of the Democrats, they were going to destroy the country. So Adams thought, I'm going to do everything I can before I leave office to keep them from destroying the country. And so he made a bunch of judicial appointments at the very end. So they passed another judicial act. The outgoing Federalist Congress, the lame duck Congress, passed another judicial act right before the end of their term, and expanded the judiciary a lot. And Adams appointed everybody. And the goal is like, if we're losing political control of the legislature, then maybe we can hold on to legal control and keep the country together, because these Democrats are going to tear it apart. That was the thinking. One of these people that was appointed was John Marshall. So he was appointed to the Supreme Court. So they were called the midnight appointments, because this is probably apocryphal, but they spent a lot of time picking and confirming the new justices, making sure they were kind of on their side politically. And faced with the deadline of March 3rd, 1801, right before the inauguration of Thomas Jefferson, to confirm these judges, and then the clerks had to deliver their commissions to the Secretary of State, who was Marshall, and who then signed those documents, and then that made the appointment official. So the one account was that the incoming Attorney General walked into Marshall's office with Jefferson's watch in his hand, pointing to it and saying that midnight had come and you have to leave. and that was why it was called the midnight appointments, because he was literally assigning the documents, appointing people up until midnight, when his term of office as Secretary of State ended. So that was the beginning of the case. What were called the Democratic Republicans, they tried their best to undermine those judges and tried to get rid of them. And the new Secretary of State, James Madison, was directed to only deliver some of these commissions. So Marshall had signed them. The incoming Secretary of State was supposed to deliver them, and Jefferson directed him only to deliver some of them. Of the ones who didn't get delivered, only 4 complained. There were 17 or 18 of them who didn't get delivered, and 4 of them complained, and one of them was William Marbury, and he filed a suit which got to the Supreme Court against Secretary Madison, saying that he had not carried out his duty to appoint him. So the suit languished in the in the clerk's office for a couple years, and the court actually didn't have any business until 1803, and then they took up this case. The Chief Justice, who by that time was John Marshall, he issued the court's opinion in 1803 and said that Marbury should have been able to take his his seat, which he ended up not. And the question was, could the court order the executive branch to deliver it? The court said yes, that the court had jurisdiction over deciding whether or not this kind of thing had to happen. And it turned out that Marbury ended up not taking his seat, but the Republican opposition tried to say, well, the Judiciary Act was unconstitutional. Like they shouldn't have even be able to pass that. And then Marshall issued an opinion, no, it was. And who decides what's unconstitutional is the court. Haha, shut up. So that was the more important part of the case, that ultimate constitutionality was determined by the court, not the Congress. As the Republicans tried to argue, or Jeffersonians tried to argue, that no, that we have the power here, and no, the court said no, we are the ones who determine what was supposed to happen, and we're the ones who determine what law is right and what law you have to follow, because we are the most advanced arbiters of constitutionality. So that kind of set the court into what it became, and Marshall extended that power several times over several more cases that pretty much established the court's power. So how it expanded its power, a couple different cases I'll just briefly touch on. McCullough versus Maryland, 1819, a Marshall decision or a Marshall written opinion. The question was, could a state tax a national institution? In this case, the Bank of the United States, which was not very popular in the state in question, which was Maryland. The cashier of the Baltimore branch of the National Bank was a guy named James McCullough. He refused to pay the tax that Maryland had assessed on the bank. The state appeals court held that the Bank of the United States was unconstitutional because the Constitution did not provide explicit power for the government to establish a bank, which was a Republican opinion, or by this time Democratic, kind of the same thing at the time. And so the question was, does Congress have the authority to establish a bank? Yes or no? That had been the opinion of Alexander Hamilton back in the day. And the second question was, can Maryland law interfere with Congress's powers to do so? Marshall issued the majority opinion, which was unanimous. Congress does have that power under the necessary and proper clause of the United States to charter a bank. And secondly, the state cannot trump federal law. If it's a federal thing, a state can't just tax it. It's because the federal government's more powerful than the state. Gibbons v. Ogden, basically that one was a decision that established that the federal government had the power to regulate interstate commerce. It was a dispute about steamboat operators, and that a guy named there was a steamboat line between New York and New Jersey, and New York tried to create a monopoly or something. And one monopoly was controlled by this guy named Gibbons, and then there was another company controlled by this guy Ogden. And the states were trying to say that one couldn't run in the other's waters, basically. And the Congress or Marshall issued the opinion, no, the federal government is in charge of interstate commerce, which again increased the power of the court, because the court would be the one to arbitrate these things, not the state. The other more famous one that you've probably heard of was the case of Worcester v. Georgia, which involved whether or not the state of Georgia had the authority to regulate the relations between its citizens and the citizens of the Cherokee Nation, which was recognized as a nation by the United States. And the Constitution does give the power to the federal government to deal with Native nations, Native American nations, not the states. Georgia was basically saying, we want that land. We don't care. And so what Georgia was doing for years was basically ignoring all the treaties that the Cherokee Nation had with the United States. The Cherokee made, and this is an important part of American history, the Cherokee made an interesting move to resist the United States in that they created their own constitution. It was accepted by the United States, and they said, we are an independent nation within the United States, and we have a constitution, we have a language, we have schools, we have our own various institutions, newspapers and whatnot, and we have our own laws, and we have our own autonomous country here, and we deal directly with the United States, not with Georgia. But Georgia's trying to say we don't own the land that we own. So they took that to the Supreme Court. The Cherokee had quite powerful allies in the federal government, and one of the allies was the former Attorney General of the United States under John Quincy Adams in the prior administration, the 1830s, a guy named William Wirt. And he made that argument to the court, and the court agreed. So the court made a very strong decision in favor of the Cherokee, which said, yes, the Cherokee are a separate political entity, and Georgia cannot make laws for them. Now, this created a situation that Marshall was afraid of, where if the court can make a decision, who's going to enforce it? And Andrew Jackson chose not to enforce it. He didn't have to for very long, because what the President Andrew Jackson did was get a new treaty fraudulently signed, which accomplished his political goal, which was to remove the Cherokee from their land. And so the actual question of whether or not this is going to be enforced didn't really come to a head, because the new treaty happened pretty quick, which was fraudulently obtained. But from the legal standpoint, the court felt it had done its job here. Although there was concern, and this was always Marshall's concern, of what is the actual power of the court if people don't listen, if the executive authority doesn't listen to it. So that was the early years of the court. The mid 19th century was kind of dominated, or in American history, dominated by the questions of slavery, and two cases stand out here under the next Supreme Court Justice, Roger B. Taney, who took over after Marshall after 1835 and his death. The one case was called Prigg v. Pennsylvania in 1843, in which the Pennsylvania legislature passed laws prohibiting the removal of Black people out of their state for the purpose of enslaving them. A Black woman named Margaret Morgan had moved from Maryland to Pennsylvania. She was never formally freed, but her owner granted her kind of virtual freedom. When her owner died, his heirs wanted to collect their property, and so they said she needs to come back. She said she wasn't coming back, and they sent a guy to capture her in Pennsylvania. His name was Edward Prigg. So he was arrested for breaking Pennsylvania law, for trying to kidnap and take this person back into slavery. And he argued unsuccessfului that those laws were unconstitutional that Pennsylvania had passed. The Supreme Court had to step in here and say, were those anti-extradition laws constitutional? And did they violate the Constitution? The court said no. The court ruled that those laws were unconstitutional and that federal fugitive slave law took precedence over those state laws. And so Morgan was returned to slavery. And the most famous case of that period was the Dred Scott case. Dred Scott was a slave, and he had spent time with his master, who was an army surgeon, who took him to northern states and spent a lot of time there. And under the state laws, there were exceptions made for people who had this kind of situation. And upon the death of the master, a lot of times that person would be freed legally. Their slave would be freed legally because they had spent so much time in the free territory. And the free states had a number of what were called liberty laws that you could argue, okay, I was a slave, but my master took me to Illinois and I spent 8 years there, and he's now dead, and so I'm no longer a slave now that I reside in Illinois. His heirs can't claim me, but his owner's heirs, they made an argument they could, and so this went up to the Supreme Court. And Taney at the time tried to basically resolve the slavery question that was vexing the country at the time by taking the southern side, and made one of the most notorious Supreme Court opinions of all time, in which he said that Dred Scott, his case was illegitimate because he was not a citizen, nor did he have any rights. And he actually used the phrase, had no rights, which a white person need respect, because he was a black person. And he went further. Taney was actually more racist than most white people at the time. He went further and said that no black person, either slave or free, has any protections under the Constitution. The slaves are classified as property. The free blacks are kind of classified as kind of an unclear category with minimal rights, if any. So he was thinking he would resolve the slavery question, which was becoming more tense in the 1850s, but all that did was really make the situation worse and really directly led to the Civil War. Average Northerners were just livid at the idea that their state's laws could just be trumped by the claims of Southern slaveholders. And Taney said that was not only correct, but like right and proper. Like the northern states, he went further than that and said the northern states had an obligation to enforce the fugitive slave laws, and that attempts to regulate slavery or regulate people's property, said the property is inviolable. He cited the Fifth Amendment and said slave owners can take their property wherever they want, and they're still property. They don't become free. So just because you take them somewhere, and so that just inflamed the slavery dispute and just made things worse. So he helped cause the Civil War in that case. The Dred Scott case became the number one issue of the 1860, or one of the top issues of the 1860 election, in which Abraham Lincoln won. And then the Civil War happened. Ironically enough, Taney tried to rule during the Civil War that President Lincoln was prosecuting an illegal war effort, and Lincoln just ignored that. So this was a case of like the court going too far in taking a particular ideological stand, and when it did that, it reduced its own legitimacy. The court in the next few years, this was a more critical period that people have been more critical of it for. It heard a number of cases in which it didn't really protect minority rights. And some of these cases are cited as situations in which the court did not enforce the laws and amendments that had been meant to make things better for citizens. Instead, it chose not to enforce or chose not to affirm them, and then they didn't get enforced, and the court didn't care. And so it seemed to be failing civil rights here. And so this period of the court, Chase, Waite, and Fuller courts had a number of cases in which they kind of failed to uphold what were called the Reconstruction Amendments. So following the Civil War, the Republican Party knew there were going to be legal challenges to the changes made by the Civil War. And so they wanted to try to lock those in as much as possible. So they passed what were basically probably the most important pieces of legislation in American history in terms of civil rights, the 13th, 14th, and 15th Amendments to the Constitution, which locked in what the Civil War had been about, essentially, like locked in the changes of it. So 13th Amendment abolished slavery. 14th Amendment, states cannot take away rights of individuals. And 15th Amendment, states cannot take away the ability to vote to a Black person. So the problem was those weren't enforced. So, and the court kind of affirmed the non-enforcement of states. So as an example of how those are some of those cases that did that, the slaughterhouse cases came out of Louisiana. A group of butchers argued that because of a law that Louisiana passed that restricted slaughterhouse operations to a single corporation, no one else was allowed to slaughter animals for a certain number of years. And a group of butchers argued they would lose their right to practice their trade and earn a livelihood under a monopoly, or trying to compete with a monopoly. And they argued that monopoly created involuntary servitude that violated the 13th Amendment. The court held that the monopoly did not violate either the 13th or 14th Amendments, reasoning that those amendments were passed with a narrow intent to grant full equality to former slaves. So it did not guarantee what the amendment said it guaranteed was what the slaughterhouse cases, what the justices decided in the slaughterhouse cases. Another 14th Amendment case came up with Bradwell v. Illinois the same year, which was part of the feminist movement of the late 19th century. A woman named Myra Bradwell asserted that she had the right to practice law in Illinois as a result of being a United States citizen, and that if it didn't give her the license to practice law, it was violating the 14th Amendment, taking away equal protection. And the court ruled that the right to practice law in a state's courts was not covered by the 14th Amendment. So it ruled that didn't count, basically, for her. It also went they went a little further and said the respective spheres of men and women have to be maintained. The Henry Debs case, that was a case in which the court ruled that a federal injunction against a strike was appropriate and part of the government's necessary and proper clause. And so this basically took away rights of workers to strike. And the person bringing that case was the leader of the railway union at the time, Eugene Debs, who was so dismayed by the court not upholding his right to what he believed was he and his organization's right to assembly, that he became a socialist. And then Lochner versus New York, in which the bakeries in New York City were asking their workers to work very long hours. And the state of New York passed a law saying that they could only work the bakeries could only work their workers 10 hours per day or 60 hours per week. Lochner was working them more than that, and he was fined for breaking that law. And he sued New York on the ground that the law violated his freedom of contract, protected by the Due Process Clause of the 14th Amendment. And so this was a case where the court ruled, using the 14th Amendment, that the state had violated his rights as an owner of that business, and that he had a constitutionally protected right to freedom of contract. And so that set back the ability of states to regulate working hours and things like that. They had to do it more carefully, and the court struck down things like minimum wage laws in the 1920s. That was not not overturned until the 1930s and 40s, when some new court cases reversed those. This era was seen as a time when the court didn't protect rights. Probably the worst one was the Plessy versus Ferguson case, in which the court ruled that non-enforcement of the 14th Amendment was appropriate as long as separate but equal accommodations were made for the races. So what states started to do, this didn't start until about the 1880s, as a new generation of politicians took over after the Civil War. States started to put in a whole bunch of laws that separated white and black from all kinds of crazy things, in all kinds of accommodations, which wouldn't even have been thought of before. And the goal was basically to keep control, basically, of the non-white populations. So a guy who argued that this violated his rights was a guy named Homer Plessy, who was classified as black under the law in Louisiana because he was 1/8 black. But because he legally was still a black person, he wasn't allowed to sit in the first class train car in New Orleans. So he sued that this violated his 14th Amendment rights. The decision made by the court was 7-1 in favor of the state, which said that his rights were not violated as long as the accommodations were made equal. If they were separate, but they were still equal, that was okay under the 14th Amendment. So that pretty much paved the way for what we know of as Jim Crow or segregation, which lasted, it then exploded in the early 20th century in the southern states especially, but all over the country to some extent, and solidified in those restrictions against black people's civil rights for 70 years. Some of the cases that came out of the early 20th century, by the justices during that period. So some of the things that were concerning them: how much power did the government have to investigate people? As an example, the Abrams versus United States case, that was a case where there was these leaders of a strike were sentenced to prison because they had broken they had broken the restrictions against seditious speech that were passed during World War I in 1919 in response to the Russian Revolution. The court ruled that the litigants argued that they were arrested under what was called the Espionage Act, but that was unconstitutional. The court ruled that no, the Espionage Act satisfied the clear and present danger standard of the Constitution. Another one was, or how far can you go in law enforcement, was a case during the Prohibition era in which federal agents, called Olmstead versus United States, federal agents placed wiretaps in the basement of a guy named Roy Olmstead. in Washington, where he was accused of bootlegging alcohol, and so they installed wiretaps on his phones. And he had a business that had phones, which was kind of technologically advanced for the time. And his argument was the evidence that the police collected on him was unconstitutional. It violated his right to Fourth and Fifth Amendment rights against unreasonable search and seizure by invading his privacy. The court ruled that no, the telephone conversations that they recorded did not violate his Fourth and Fifth Amendment rights. They ruled that that the rights were not infringed. And that those terms I only refer to physical examinations of one's papers. However, that did bring about an important dissent by Justice Louis Brandeis, who said there was some right to privacy. So even though Olmsted lost the case, the dissent that Justice Brandeis made was that people have a right to privacy that's implied in the Fourth and Fifth Amendments, which that became very important in future cases. The mid-20th century New Deal and World War II era also dealt with the rights of government. So various New Deal cases. Franklin Roosevelt became president during the 1930s. The court had been selected by his predecessors, and they were against most of the New Deal provisions. And they struck a lot of them down. And the result was a lot of the New Deal, especially the biggest program of it, the National Recovery Administration, being struck down was unconstitutional. The court found that the presidents do not have the power under the Constitution to regulate commerce to the extent that it was trying to regulate. As a result, that caused a conflict with the Supreme Court, and the president. But ironically enough, Franklin Roosevelt was president for so long, even though he lost that initial conflict of trying to change the court, he ended up serving for so long that he appointed 8 of the 9 justices at one point. Another case out of that time period, or set of cases, were these cases of whether the schools could compel kids to do pledges to the flag and all this, and whether or not they could get their parents could get put in jail if they didn't. Cases came out of West Virginia where these parents got put in jail. They were Jehovah's Witnesses because they wouldn't let their kids do the pledge. And the court actually found that that was one of their First Amendment rights, and that was actually very unpopular at the time. A lot of Americans disagreed with being unpatriotic. Jehovah's Witnesses were discriminated against back then. Then the Korematsu case, which is famous for its the Supreme Court affirmed the legality of Japanese internment, saying their Fourth, Fifth Amendment rights were not violated because the Constitution gives powers to the president to act in times of emergency, and that was a time of emergency. And so the court ruled that the Japanese internment was appropriate, which was seen as a stain on the court's reputation. The civil rights era is probably the era in which the court had its best reputation. So the civil rights movement took a court-first strategy, which was innovative. They had failed for many years to make inroads against the Jim Crow laws and segregation in legislatures, and so they thought, well, can we use the courts? Now that we've got new generations of justices, maybe we can argue that against the Plessy versus Ferguson case, which was successful in Brown v. Board of Education. Brown v. Board of Education was a consolidation of several cases arising out of several states in which African-American students hadn't been allowed to go to public schools based on the segregation laws. And they argued that segregation violated the Equal Protection Clause of the 14th Amendment. The decision was unanimous under the new Supreme Court Chief Justice Earl Warren, which ruled that separate but equal facilities for racial minorities was inherently unequal, that there was no way to make that equal, and that violated the 14th Amendment, which really was the 14th. This changed the way the 14th Amendment became kind of the centerpiece of all our civil rights, and so it set a very important precedent. Another important case, which we've all heard if you've ever watched a legal TV show, that you hear, you have the right to remain silent from the cops. That came from a court case, Miranda v. Arizona, in which was another combination of cases in which the defendants argued that their Fifth Amendment protection against self-incrimination was violated by the police, who interrogated them aggressively and forced them into confessions that they wouldn't otherwise have. And so the decision was made that what those law enforcement agencies had done had violated their Fifth Amendment rights. And the court reasoned that procedural safeguards were required, and as a result, to protect themselves against suit, law enforcement agencies around the country started reading this script basically to everyone they arrested, which now is kind of famous in every TV show about cops. So at the time, it was quite controversial. Richard Nixon actually ran against it in his 1968 presidential campaign, saying like the court was being soft on crime, like coddling criminals and all this. And Brown v. Board of Education was also very controversial and unpopular in certain with a certain segment of the population. The big one out of this era was Roe v. Wade, which is the one we hear about a lot now, since it was just ruled or just reversed. The decision at the time was surprisingly not very controversial. If you'd have ranked the top 10 news stories of 1973 by their popularity or by the intensity, Roe v. Wade would have been in the top like 10 or so, but like right at the end of that list, like number 9 or number 10. Which is evidenced by the front page of the New York Times that day after it was decided. The much bigger news was that former President Lyndon Johnson had just died. So, what the case involved was a woman. They called her Jane Roe to protect her identity, but her name was Norma McCorvey, and she filed a lawsuit against Henry Wade, the district attorney of Dallas County, Texas, where she lived, challenging that a Texas law that made abortion illegal violated her right to personal privacy, which was protected by the First, Fourth, Fifth, Ninth, and 14th Amendments. There was this implied right. Some of that was written about in the Brandeis dissent in that 1928 case. So the question was, does the Constitution recognize a woman's right to terminate a pregnancy as part of medical privacy? This right to privacy that is implied in the Constitution, but not specifically enumerated. The decision was yes, that it was inherent in the Due Process Clause of the 14th Amendment that protects a pregnant woman's choice whether or not to have an abortion. But there were caveats, and this had to do with what was called the Roe standard. So if you read the decision now, it was very much focused on the medical aspect of it. And it's interesting now that it was not as controversial as it became, because the justice who wrote the majority opinion, Justice Blackmun, had a background as a doctor, and he researched a lot of the medical issues in this case, and a lot of the decision has to do with the medical necessity and the law not really. The law already being contrary to a lot of medical issues, which involve people's decision making with their doctors, and so it was seen at the time as kind of a medical efficiency issue, and surprisingly not terribly controversial when it first happened. Abortion was not the number one issue of feminists at the time. It was an issue of the more radical feminists, and it was not a number one issue of religious conservatives either. Abortion was kind of seen as something unpleasant that at this time some states had legalized, some states hadn't, and it was kind of a legal mess, and the court thought this is going to make it much more efficient. And it's also going to and it's also part of your rights to make a decision with your doctor about your body's or about a woman's bodily autonomy. But so when it came out, it wasn't seen as a huge victory for women's rights. It was seen as a moderate step towards women controlling their medical decisions, which at this time there were still cases where women had to like ask their husbands to go with them to the doctor to get pills prescribed and something like this. So this was reacting to some of that kind of issue. And over the next 10 years, though, it became a big political issue, which the court at the time did not anticipate. If they had, I imagine they would have written it a little differently, but they didn't think it was going to be as big of a deal as it was. In the last 20, 30 years, there's so many issues I could talk about, and I just focused on a couple here, but you could talk about gun control, prayer in schools, terrorism, or to what extent can the government hold people indefinitely. All these kinds of cases have been hashed out by the Supreme Court in the last 20, 30 years. Two of the bigger ones, I think, probably the biggest, I would say, in the civil rights category, or the series of LGBT rights decisions that culminated with the Obergefell decision in 2015, which basically said that it is a violation of your equal protection rights for a state to say that an LGBT couple can't get married. That was basically proven when the California Supreme Court struck down its gay marriage ban. That same reasoning applied to the country. And so the Supreme Court ruled that in 2015, which effectively legalized same-sex marriage around the country. Yeah, something else the court has done that's controversial is Citizens United versus FEC, that made the decision that the Federal Elections Commission could not regulate group political spending. It ruled that group political spending was equivalent to speech under the First Amendment. And so these attempts to restrict how much money gets given to political action committees and all this was unconstitutional. And so that's been a point of contention in the last few years. Obviously, the biggest controversy is that they just reversed the Roe v. Wade decision in the Dobbs case, which in 2022, which is a fairly significant, I don't want to make it downplay it, but the court doesn't reverse its big decisions very often. It did in Brown v. Board of Education. So this is kind of on that level of, here's a precedent that's been legal precedent for quite a few decades, and we're going to reverse it. It's rare that the court goes backward like that, but that was a case where it did. The other court's roles, it has a role in impeachment. The Chief Justice is the impeachment presiding judge in the Senate. William Rehnquist joked that in the Clinton impeachment trial, he did nothing and he was good at it. Even though he has to preside over the case, but not say anything. You can impeach Supreme Court justices, and one was a guy named Samuel Chase. He was impeached in 1805, basically because the opposition party didn't like him, and he was mean. But this was a part of the problem with the way justices were in the 19th century. They were much more partisan, and so Samuel Chase very aggressively prosecuted what were called the Alien and Sedition Acts, and in the 1790s and early 1800s. And then a little later, he called Thomas Jefferson the leader of a mobocracy or something. And anyway, the Constitution says you can impeach, the justices can be impeached. It doesn't say why, but good conduct is one of the reasons why. And so the Congress at the time the House impeached Justice Chase over basically saying he was partisan, which he was. But the Senate did not convict him. So there were like 8 different articles. And so he was impeached by the House, but not removed, although he did kind of shut up his political opinions after he was impeached by the House. But that was the only time a Supreme Court justice was ever impeached. You can technically impeach any of them for kind of any reason, although the Congress hasn't done that. What's changed in the last few years, I think, or the last 30 years, is that nominations to the court are a much bigger deal than they ever were. Part of that is because the justices stay on longer than they ever did before. In the 19th and 20th centuries, it was rare for a justice to stay more than about 15 years. I think the average was about 14, 15 until the 1990s. So, and there'd be a couple justices that would stay on 25 or so, 25, 30. But most of them, 10 to 15 years, they'd resign or die or something. And then they get replaced. And so it wasn't so high stakes. Lately, the tenure of the justices has been increasing to this 20, 30 plus year tenure, which the framers probably didn't anticipate. The framers certainly would not have wanted one president to have such an enormous influence on the future through the Supreme Court appointments. If they had predicted that, I'm sure they could have seen that. I'm sure they would have changed the way appointments work. But they didn't see that. They didn't think the justices were that big of a deal, and so that's why they didn't worry about it. It's just like, well, as long as they're not misbehaving, they'll stay in office. So but now the justices are more kind of part of the political argument, and this has been an issue. It kind of started with the Bork nomination in 1987 by Ronald Reagan, and because Robert Bork was very opposed to a lot of the actions of the Warren Court during the Civil Rights era. So that became a big deal. And then kind of personal issues with the justices have become a big deal lately. The Anita Hill accusations against Clarence Thomas in 91, and then the Kavanaugh accusations in 2018, that becomes a bigger issue. And then President Trump did something interesting when he ran for president in 2016. He had a list of justices, and he's like, "This is why you should elect me, because here's my list of people who I will choose from." That had never really been a campaign issue. They didn't really campaign on the way they're going to nominate. Presidents didn't really campaign the way they're going to nominate justices very much. Sometimes they complain about what the justices did or that they made bad decisions, but the closest to that would probably have been Richard Nixon in 1968, who did complain about the soft on crime cases. But that wasn't quite as big a campaign issue as has been made recently. And so in recent years, the court is much higher stakes, and the nominations become these circuses, which are just crazy. And I don't expect that to change because the stakes are so high now, especially now that Roe v. Wade was reversed. Now there's going to be high stakes every time there's a vacancy on the court, and everyone's going to consider that like the end of days kind of thing. The court does respond to public opinion. The civil rights cases weren't popular. Brown v. Board of Education was not very popular. And it wasn't easily enforced. And you can argue it wasn't enforced, even though they tried to enforce it through court-ordered busing. You could argue that the outcome is that schools are still segregated, even though it's not legally institutionalized. And so it didn't really work. And the court did kind of respond to public opinion by kind of backing off some of its enforcement attempts or attempt to compel enforcement by the executive branch in the states. To the extent Justice Rehnquist did say, how can you not be influenced by public opinion? So he admitted he was influenced by public opinion somewhat, and he did kind of what he thought was best in the context of what the country wanted. Not all of them operate that way, though. So public opinion can influence them, or it doesn't. It kind of depends on the justice. Supreme Court does get involved itself in elections. Probably the most famous recently was the Bush v. Gore decision, which ironically enough, this is kind of an unpopular opinion. I actually think it made the right call in that particular one. But they were heavily involved. So 4 Supreme Court justices were on the Electoral Commission to resolve the 1876 election. The court rejected the Trump attempts to argue that there was fraud and in the 2020 election. And so they involve themselves in democracy to some extent. There's also ways they can improve democracy, and they've done that before. Obviously, the 15th Amendment is pretty important, but in the civil rights enforcement of the Civil Rights Acts and the legal affirmations of that have been important, and some of those are going to get pulled back on. There was a 2013 case where they ruled parts of the Voting Rights Act unconstitutional and all this. So the court does have a say in how democracy functions, and it's kind of anti-democratic if you think about it. And the 9 people that stay on the court forever, I mean, that's not exactly democratic. You can try to reform it. The most famous case was Franklin Roosevelt tried. And what he wanted to do was, because he was so upset about the court during the 1930s invalidating New Deal programs, he said, okay, fine. He put forward a legislative proposal that would have added a justice for every justice who was over the age of 70. And so every time a justice passed age 70, the president could nominate another justice up to a maximum, I think, of 13 or 15. So that was one attempt to reform the court. There are various other ideas to reform it. We can't get rid of lifetime tenure unless we amend the Constitution. So probably the easiest reform would be to change the size. That can be done by congressional legislation. The size was created by acts of Congress. It can be changed by acts of Congress. So that's probably the most prominent way to change it. And that happened before. In the 19th century, the Congress reduced the size of the court and then expanded it again for political reasons, basically. So that's happened before. Interestingly, if you read the historiography of the court, which I've been doing a lot of, it's written by a lot of lawyers and judges who are very kind of self-righteous about the institution. Justice Breyer, in his book, he argued that the way to fix the court is for the court to be good, basically. He did argue that the court needs to be careful because if it goes too far, it loses legitimacy among the public. The court does not have enforcement authority, and so where its power comes from is soft power, is the power of its reputation. And Breyer argued that the court needed to be very careful in how it applies its decisions, because if it loses the support of the people, the goodwill, it will lose its power. And so it's kind of almost a mythical kind of power that it has, that's not quite grounded in reality. And Breyer discusses this where he met with these colleagues that were part of the high courts in different countries in Africa, and they asked him, like, how do you enforce anything? Like, why do people listen to your court? They don't listen to us. and he explained, like, it was part of kind of the interlocking aspect of the branches, and it has to do with the public opinion. And so he did try to argue to his colleagues that if they lose public confidence, they will lose the power of the court to uphold the Constitution. So that's what the people from within the court think that the court should do. Where the court's going now, who knows? I expect there will be some decisions that will make progressives unhappy going forward. There's going to be an affirmative action decision in this current term that'll come out in June. I suspect that's not going to go progressives' way. And I expect nominations will be a circus for the foreseeable future, given how high stakes they are. The next most likely justices to retire or pass on are Clarence Thomas and Samuel Alito. They're the oldest ones. And then Justice Sotomayor is not the most healthy. So one of those three may go within the next few years. Who knows? If they do, you can expect it will be an enormous brouhaha in the Congress. So where they're kind of stacked a little bit against public opinion right now. Certainly, the Roe v. Wade decision did not match public opinion. That the Dodd's decision did not match what the public wanted from them. So I expect they're going to make some decisions over the next few years that are not going to be popular, and that runs the risk, and the Chief Justice John Roberts is very aware of this, that runs the risk of doing what Breyer warned, which is it loses its legitimacy, which courts in the past have found does matter. The court's decisions can be ignored. So that is my discussion of the court's history. And I got in just over an hour, so it didn't do too bad. So I'll take any questions, and thank you for listening to that. And I apologize for any legal errors I may have made. I'll take any questions.
Thank you, Murray. This was fascinating. It's amazing how you can condense, 400 plus years of history into really just over an hour. So that's a feat in itself, especially when it's something as complex as the relationship of the court now to the people and back to the origins of the court and what the intentions were. So we're seeing kind of a discrepancy between the execution and the intention of the court, which is something that I have heard people say when it comes to our country in general lately, how there's this really big gap between what the founders wanted, what the founders intended, and what the actual reality of our new world is. There are just so many things that one couldn't have anticipated. And so it's really interesting to see how that is applied to the Supreme Court. Something that you said just now that was particularly fascinating was how you referenced the public opinion and how public opinion could influence the court, because that is something that we've been seeing a lot more of recently. In general, people's right to assembly, people who are standing up and saying this can't be done. And yet the Supreme Court does, in a way, seem to be above all of that. Can you tell me, how would a layman, you or I, even begin the process of bringing up an issue that we wanted to make it all the way to the Supreme Court? Can you go back to that really basic premise there? I know it's kind of a little bit government. You're like, this is high school government class, but if you can you just relay that process for us a little bit?
Yeah, well, the court makes its own decision. So it has to do with all the rules that they've developed over the years through tradition. The court makes its own decisions of what cases to take, and it's kind of their discretion. They can choose not. So the famous example of choosing not are all those Trump cases. He launched like however many 30 lawsuits, arguing various violations of election law and saying they were violating the Constitution or something. And the court was just like, no, this isn't even worth our time discussing. And so that. And you have to have certain standing with the court, or like there's certain. I'm not a lawyer, so I can explain it well. But there's the litigants have to have certain standing in order for it to be a case that actually goes that high. And then the courts, the cases that go from the district to the circuit level to the Supreme Court, there's a certain package of cases that gets submitted that kind of meet the standards, and then the justices have to agree on which ones. There has to be a majority of the justices agree on which ones to take. So that's kind of the process of how it gets there. They can only handle so many per year. I think it's something like 200 or something that they may process per year.
Fascinating. That was the next question, is how you, as you noted at the very beginning of the Supreme Court's appointments of justices, they didn't really have much to do. So now you're saying that around 200 cases get
something like that. Don't quote me on that number, but it's a limited number that they take.
And
They do a lot more work now. So if you look at their workload, their clerks work so much more. And there's definitely more of an industry now to the court cases. And as recently as when I was reading about one of these cases, one of the 40s ones, that I think it was one of the flag cases that I was reading about. The justices did their own work, and they took their own homework, and then they wrote the briefs themselves and the decisions themselves, and the clerks just kind of did the typing. Like William Rehnquist, it comes from his book. He was one of those clerks, and a lot of his job was literally kind of typing out what they came out with. And so the workload is much more of an industry now. It's just a much more expansive enterprise. To give a sense of how much more important it is now, they didn't even have a building of their own until 1933. So the Supreme Court building they have was opened in 1933. Before that, they had whatever other courthouses that they used, which weren't specific to them. So it's in the 20th century, it's really ratcheted up as a much more important institution.
Fascinating. And you mentioned here how the Supreme Court will give a ruling, and then should an entity, an organization, a person, should they decide not to abide by the ruling, what are the ramifications? What's done?
The whole government works together, ideally. So the Congress makes a law, and the law goes into effect, and then if the court rules on it, then the enforcement law is up to the executive, and then the enforcement of the law is carried out by them. If that doesn't happen, then nothing happens. I mean, it's kind of an honor system if you think about it. That's the kind of crazy thing, is like there's somewhat of an honor system behind this. And Brown v. Board of Education is a good example. The court said this segregation of the schools is illegal. And so the states did their jobs, and the states basically deleted the segregation laws. So they said, okay, the court said these laws are unconstitutional, so we're deleting them. We did our job. But the schools still were segregated. Like, all that did was just kind of change the wording. So the courts came back in the 50s and then in the 60s and said, okay, because people sued again and said, well, there's still segregation, and they sued again, and they got back to the court. And so the court replied again, okay, we're going to set a schedule, and the schools in question in these counties and cities have this much time to segregate. You've got to do it this way. One way we suggest is by busing. And so court-ordered busing was a big deal in the 60s and 70s. Some jurisdictions just didn't do it. They were just like, nope, not going to run the buses. And some districts did. And it was up to the law enforcement authorities in the area to enforce it. And if they didn't, it just didn't happen. And then it just kind of stopped happening. And then busing was ruled. It was ruled in the 80s that the jurisdictions didn't have to do busing. So they reversed some of those decisions from the 60s. So then the jurisdictions are just like, oh, we're not going to do it. So it's an honor system, really. like if enough of the government just says nope. And the Dred Scott decision had the same effect. Like, northern states were just like, no, like, we're not going to enforce this, and you come and make us. You hear that now with states, law enforcement agencies saying they're not going to enforce any gun control provisions. So if the Supreme Court were to say gun control is legal, it doesn't violate the Second Amendment if state of Illinois or wherever wants to take your AR-15, if the police just say we're not going to do it, it doesn't get done. It's on paper, but it just doesn't happen. So sometimes the court will revisit those and kind of change to fit what's actually happening. Other times you just kind of leave it on the books and it just kind of continues. It depends on the integrity of the people in the system, really.
And I hear they're also going back to how important the public is, how important civic duty is then in these instances where something can only be upheld if somebody is holding one's feet to the fire, if you will. It's our important civic duty to remain informed about what's going on at the top tier of our government so that we can make sure that we are doing our small part, because small parts lead to big masses, lead to big change. And hopefully that state remains true. That's one of the protected rights in our Constitution, after all. So how does one in today's day and age, though, keep a close eye on what the Supreme Court is doing? How do we find out about these cases? Can you tell us a little bit about how do we begin that research?
Well, there's all kinds of information. I mean, every news agency usually has a division that focuses on the court. The court puts out a lot of good information. They're pretty open about, at least once they're done. Like when they're working, they're pretty secretive, but then once they finish, like they're pretty open with all their information and how they came about to their reasoning. So the court itself puts that all online. It used to be a lot harder to get that stuff, and now that it's all online, you can get stuff that used to take you days to order from libraries and the different like processes of getting the information. So yeah, now you can just look it up online because they post it. And I think being aware of what your rights are is important. It's like you need to know, what your rights are, when they might be being violated, and that's what lawyers exist for. If like your rights are being violated, then you can start the process of putting the legal system to work. That all these rights exist for all of us by virtue of living in the United States. So yeah, it's partly awareness and continuity on the part of individuals.
Absolutely. And that's why we're here. That's why we're here tonight, is to explore justice in all its forms across the United States so that we as citizens can remain aware, just like you said, of what is owed to us and what we can and should and need to fight for. And Murray, thank you so much for taking your time tonight to talk to us about the Supreme Court and its this huge entity and the really long, varied history of it. This was very informative. And don't forget, to everyone out there, that the library is a great place to come. If you have questions about justice, if you have questions about resources for you from your community, the library is a great place to start because we have so many good resources for you, including free access to lawyers every week. So we are going to be exploring that all through No Justice, and we hope to see you then at all the other great fun free programs we're offering. Check out DeschutesLibrary.org for everything else that's upcoming in your area, and we hope to see you again soon. Murray, thank you again for tonight. We will leave it there and say good night, and hope to see everyone very soon.
Thank you.
Great. Thanks.
Bye.